If someone maliciously smashes your storefront window, the law might force them to pay extra as a punishment. But if a business partner breaks a signed agreement, the legal reaction is completely different. Contract law strictly forbids treating a broken promise like a crime. Unless the breach involves an independent, intentional tort, you cannot sue for punitive damages. You also cannot claim compensation for the emotional distress of dealing with a reneged deal. Instead of seeking vengeance, courts apply a cold mathematical calculus. The entire system is engineered for pure economic efficiency, designed solely to repair specific financial harm. To a judge, a breached contract is rarely a moral failing that deserves a penalty. It is simply an accounting error, and the court's only job is to balance the ledger. This diagram illustrates exactly how that baseline math works. Imagine you sign a contract to buy a house for $200,000, but the seller backs out. To get an equivalent house down the street, you are forced to spend $210,000. The court's first priority is to satisfy your expectation interest. This means placing you in the exact financial position you would have occupied if the deal had gone through. Here, that gap is the extra $10,000 you had to spend, so the breaching seller owes you that difference. Sometimes that expectation is too difficult to calculate. In that case, the court looks at your reliance interest. If you spent $400 on an appraisal for that first house, the court will refund that wasted expense to put you back to square one. Finally, there is the restitution interest. If you gave the seller a $5,000 down payment, the court forces them to return it. The goal here is simple: prevent the rule breaker from keeping a direct financial windfall from an agreement they abandoned. The first major barrier to getting paid is a rule that limits exactly what kinds of harm the rule breaker is responsible for. Stemming from the 19th century case Hadley v. Baxendale, the law dictates that a victim cannot recover losses for bizarre, unpredictable domino effects. If a delayed shipment causes your factory to lose a lucrative, highly unusual side contract, the shipping company is not on the hook for that lost profit. Courts apply an objective standard. You can only recover damages for indirect harm if a reasonable person in the breaching party's shoes could have anticipated that specific fallout at the exact moment they signed the contract. Foreseeability acts as the economy's safety valve. It ensures that a single missed deadline doesn't saddle a business with infinite liability. Even if your damages are entirely predictable, you face a final step in the court's calculus. The law requires you to minimize your own losses, a concept known as the duty to mitigate. This takes two forms. The first is passive mitigation. If you're hired to build a bridge and the county abruptly cancels the project, you have to immediately put down your tools. You cannot keep pouring concrete, rack up useless expenses, and expect the county to foot the bill. And the second form is affirmative mitigation. If you are wrongfully fired from a job, you are legally obligated to actively search for alternative work to replace your lost income. Take a look at this bar chart to see exactly how that impacts your payout. If your boss fires you and breaks a $100,000 contract, but you refuse to take a comparable open job offering $90,000, the court subtracts that $90,000 block. Your failure to mitigate drops your final award to just $10,000. But the definition of a comparable alternative has distinct limits, as illustrated by the famous contract dispute involving actress Shirley MacLaine. 20th Century Fox breached MacLaine's contract to star in a movie musical. To mitigate the damages, the studio offered her the lead role in a dramatic Western, co-starring Clint Eastwood. When she refused the Western, the studio argued they shouldn't have to pay her original salary. The court sided with MacLaine. Because a dramatic Western was a vastly different and arguably inferior role compared to a musical, it did not qualify as substantially similar employment. She had no legal obligation to accept it, so her refusal did not reduce her payout. The duty to mitigate forces the victim to share the responsibility of keeping the total economic fallout as small as possible. There is one major exception to this deduction rule, and it applies to businesses operating as a lost volume supplier. Think of a large construction firm or a hardware store. If a customer cancels an order, the business might easily find a second buyer for those same materials. But because they have expanding capacity and extra inventory, they could have serviced both customers simultaneously. That second sale is an entirely independent transaction, not a substitute for the broken deal. Because of this, the court will not deduct the profits from the second sale out of the expectation damages owed by the first customer. These rigid rules, from expectation baselines to mandatory mitigation, all serve a single unifying philosophy. Contract law refuses to reward economic waste from either party. The legal system will meticulously calculate and repair your broken expectations, but it only awards that cash if you act rationally, minimize the damage, and take steps to help yourself.